Hi there, this is Jonathan Ginsberg. I'm an Atlanta area personal bankruptcy attorney, and today I'd like to talk to you about a situation that we're seeing, maybe not all the time, but fairly frequently, and that is when the collection law firm that has sued you and won a judgment is no longer. They've gone out of business, they're defunct, they cannot be found. And specifically, I see this a lot from a law firm called Mann Bracken. Mann Bracken was a big collection law firm here in Atlanta. They sued people not just in Atlanta, but also nationwide. And a few years ago, for various reasons, they went out of business. They are no longer, there is no successor firm, there is basically nothing there. The problem is there are a lot of people out there who were sued by Mann Bracken, and Mann Bracken was also, by the way, a debt buyer in addition to a collection law firm. So there are a lot of people out there who have judgments against them in favor of Mann Bracken. And this doesn't just apply to Mann Bracken. There are other law firms that are similar to this. So again, a situation where the law firm or the collection agency or the debt buyer is out of business. You've got a judgment against you. You can't get new credit. You can't qualify for a mortgage or a car loan. What can you do? And so here's some thoughts I have about some options you've got to deal with this particular problem. First thing I would tell you to do is to look at your credit report and see if there's any sort of a successor in interest. In other words, did somebody buy the asset? Now again, a lot of times nobody has bought it, but sometimes if you look in your credit report, you'll see that there is a successor. Somebody has purchased the account from the bankruptcy trustee when that firm filed bankruptcy, or there was some sort of a trustee in a state court that actually is administering the estate of that defunct company. And you may be able to find somebody who has the account. And if that's the case, you can approach that individual, whoever owns it, or the company who owns it, and try to settle for some small percentage on the dollar, because there's a good chance that successor in interest does not have all the paperwork, and that claim may be susceptible to what's called a collateral attack. That is actually the second option. That would be to hire a lawyer and to file a collateral attack on the judgment. Now, the issue there is you've got to have some grounds to do so, meaning that you could argue that you were never properly served if you were not served, or that there was some sort of fraud on the part of the debt buyer, the collector. I don't think you can just file a collateral attack just because you don't want to pay the debt. You've got to have some basic reason for it. But as a practical matter, if you file a collateral attack and you serve Mann Bracken by publication, meaning you serve notice of the lawsuit in the newspaper where they were last incorporated, or get a judge to agree to let you to do that, there's nobody who's going to respond to it, and you would have grounds to get the judge to declare the judgment null and void, and it goes away. But again, my feeling is you've got to have some basis to make the collateral attack. Some basis to do it, there's got to be legitimate grounds. The third option would be just to wait it out. The judgment will expire. In Georgia, it'll expire after 7 years. Other places, it may be 5 years or 10 years, depends on where the judgment was issued. But if you basically wait it out, at some point the judgment will disappear by virtue of it becomes stale. Now, I would tell you that you cannot assume that the credit reporting agencies are going to necessarily know that. So what I would say is that as you get close to that deadline for the stale debt, that you file a challenge with a credit report saying this is a stale debt and it needs to come off my credit report. So you've got to watch that, because if you don't, those judgments can stay on there. Now realize that a successor in interest can renew the judgment. In Georgia, they can renew it for another 10 years and do that repeatedly. So you got to be careful to make sure there's nobody out there renewing the judgment, but assuming it's not being renewed, then you can make it go away just by virtue of time. The fourth option would be to file a bankruptcy and then to use the power of the bankruptcy court to file a motion to avoid judgment lien. And in bankruptcy, you can file a motion that basically says this judgment lien is impairing my exempt property and I want it to go away. And assuming nobody responds to it, again, if there's nobody on the other side, no one's going to respond to it, and you give proper service, whatever that means, and again, that's something to discuss with your lawyer, then the bankruptcy court has the power to declare that that judgment null and void. The debt becomes an unsecured debt, and it will be discharged either in a Chapter 7 or in a Chapter 13. So those are the options. And of course, as a bankruptcy lawyer, I get involved in doing the motion to avoid judgment lien most often. And again, the judgment will simply go away. It'll become a null and void judgment, and it's always wise to file the order from the court declaring the judgment void by virtue of impairing your exemptions. File that in the general execution docket of the county where you live. Make sure that credit agencies know about this so that this all disappears. So those are some ideas about how to deal with a Mann Bracken judgment or a judgment from another entity that's out of business. You're not powerless to deal with it. You've got to be proactive, of course, and again, especially proactive with the credit reporting agencies. But if you do that, you can get your credit restored, make all this stuff, this negative stuff go away, because again, this creditor is gone. Why should you be stuck with this debt that's going to haunt you for 7 years or longer? So I hope this has been helpful. If you did find it useful, please give it a thumbs up on YouTube or a like on Facebook. And of course, let me know if there's any questions you have about judgments from any creditor, not just Mann Bracken or other defunct creditors, or from any creditor. We can file a motion to avoid lien in those cases as well. So thank you again, and I'll talk to you next time.